Hello and welcome. This is another in the series of interviews hosted by the District of Kansas and Western District of Missouri chapter of the Federal Bar Association. These are interviews of recently appointed federal judges, and this morning we will be interviewing recently appointed, as of March of 2022, Magistrate Judge Rachel Schwartz, who you see on the screen. And I have here with me this morning to help conduct the interview, Ethan Lang, who is the president-elect of our chapter of the FBA and also a partner at the Kansas City office of Stevie Siegel. And he also has the distinction of having practiced with Judge Schwartz before she came on the bench. So hello, Ethan, how are you?
I'm fine. How are you, Judge?
Very good. So it's fun to do these interviews, and I should mention that I am the current president of this chapter of the FBA, and I'm a federal magistrate judge sitting in Kansas City in the District of Kansas. So I'm especially happy to have Judge Schwartz as a new colleague on the bench. So welcome, Judge Schwartz.
Thank you both for having me here this morning, and it's truly my privilege to have the chance to chat with both of you today.
Well, thank you for taking time. And so, Ethan, unless there's any other background, take it away. Let's start the grilling of Judge Schwartz.
So we'll get to your work, but before we do, we wanted to start off with, when you're not working, what is it that you like to do for fun?
I am a voracious reader, and I read a little bit of everything. And then I am also a bit sports obsessed. So I would say between those two things, and then pre-COVID, we used to travel a lot. We haven't really gotten back into the swing of that, but I would say those are the three things that take up all of my spare time.
All right, let's expand on each of those very briefly. What do you like to read?
Fiction. I don't really read anything that overlaps with my job. So really in the realm of fiction, anything that isn't crime-based or law-based, just really a little bit of anything.
All right, and although I know the answer to this, I have to ask the next question about your sports teams.
I am a devoted KU basketball fan. I grew up in Lawrence. I joke that when you do that in public schools, they teach you the KU fight song in grade school in music class. And we continue to go to the KU basketball games to this day. And then my other great sports love is soccer. Although sport in Kansas City is very hard to watch this year. They are having an appallingly terrible season, but it is a perfect year in my book that we have KU winning a national championship, and then the end of the year is the World Cup. That is exactly how I would design every year.
That's a great bookend. All right, and then lastly, about travel, what's your next travel destination?
We were supposed to do a big travel right at the beginning of COVID that we canceled. It was going to be our 20th anniversary, my husband and I, and we were planning to go see castles in France. So that'll be on the agenda here as soon as we can figure out how to work that in. But my travel this year is to baby judge school for 2 weeks, which is slightly less glamorous.
But invaluable, right?
It is a testament to this job that you go to school 6 months after you start. So I will find out in August everything I've been doing wrong for 6 months, but I'm very much looking forward to the school. First of all, to meet colleagues, and second of all, I just received the agenda here in the last week, and it's going to be invaluable.
It is. Baby Judges School is fantastic, and I'm sorry you haven't had it for your first, what, it'll have been 5 months on the bench before Baby Judges School. So good for you.
I'm not sure who picked, though, to have it in San Antonio in August. That seems like poor judgment, but it'll be a reminder of the heat and humidity of Texas. So,
right. Well, could you tell us again on the personal front, Judge Schwartz, where are you from? And then where did you go to law school, undergrad and law school?
I was born in Chicago, one of the Chicago suburbs, but we moved to Lawrence when I was starting the second grade. So I consider myself a Lawrencian, and grew up there, went to KU as an undergrad, and then went off to law school at the University of Michigan up in Ann Arbor.
Very good. And tell us a little bit about what caused you to choose to go to law school.
I wish I had some story that this was my calling in life. And more truthfully, it is that I graduated from KU with 3 wildly unmarketable social science degrees. And due to a love of debate back in my high school days, combined with the social science degrees, I thought law school was the path. And it wasn't until my first summer when I was out clerking as a summer associate at a law firm that I realized I actually truly had a passion for being a lawyer. And that was the start of the 20 years of being a practicing lawyer.
You know, I also had that debate background that spurred my interest, but are you like me? I don't really think debate was anything like, I mean, the whole idea that somehow arguing that sort of debate is anything similar to the law is a misconception, isn't it?
I absolutely agree. I think the only really transferable skill is, if you were really good in debate, one of the things you could do was to listen to the citations on the other side and pull those apart. And I think that gives you a good foundation for addressing the other side's supporting case law, to be able to say, look, if you read that case law and you read, the next paragraph, that's not what the court said, or it's not what the court means. That's that, and the ability to just stand up and speak, I think, are really the only transferable skills. They are, as much as you would think debate is like being a lawyer, the comparison would be TV lawyering to real lawyering. There's really no comparison at all.
That is a good analogy. And I agree with you. Debate is helpful, obviously, to being a lawyer. I learned a lot of important skills that way, but it's not like being a lawyer at all, I think. Would you agree, Ethan? Were you a debater, Ethan?
I was not a debater, so I can't add to this conversation.
Right. Okay.
But since you mentioned what it was like being a lawyer, why don't you tell us about what it was like after law school, what you did, and the nature of your practice?
I started my career down in Dallas, Texas at a big regional defense law firm. So I spent my first 3 years at a big firm doing antitrust and securities defense work. And it wasn't until 2004 that I moved back to Kansas City, home, and joined Stevie Siegel Hansen at that time. And I stayed with the firm from 2004 until I started on the bench this year. So I was there for almost 18 years.
And what was the nature of your practice?
We were a plaintiff's firm, and I did almost exclusively commercial litigation on behalf of plaintiffs. I did a lot of antitrust work, I did securities work, and a lot of MDL work. So I tended to do more complex litigation. And nearly all of my practice was in the District of Kansas. And that, as Ethan well knows, that's random in our firm. We have cases all around the country, work in the Western District all the time. And it just so happened that most of my career was spent here in the district, which was a great privilege to be in front of the judges in this district and to really learn how to be a lawyer in this district.
And Judge Schwartz, what was your favorite part of private practice before you came on the bench?
It was, and this is not in any way sucking up to Ethan, but it was truly the chance to get to work with my colleagues. I loved the strategy side of being a lawyer. And my favorite times are when I think back to those late nights where you're standing in the hallway talking to your colleagues about what we're going to do and the strategy around that. That's what I loved. I had the great privilege of working with smart, interesting people, and I truly enjoyed that.
It's great to have a good firm and good colleagues to work with. I presume also, for me, I miss the client contact. Do you miss the client relationships?
It's a little bit different on the plaintiff side because we tend not to have repeat clients. So I was lucky that we did have two who were repeat clients, and I very much enjoyed getting to work with them and building those relationships. But so many of our clients, we would only work with them once, and then we would move on to a new case. If you had a class case or even an individual business case, we didn't often get those folks a second time. So I think we spend really more time with our colleagues than maybe on the defense side, where you are building those long-term relationships with clients. So it's a little bit different.
And I know that we, the other judges here in the District of Kansas, were very familiar with you as a practitioner because of the multi-district litigation cases, class action, complex litigation that you've described that you had in this district before coming on the bench. I'm sure that was an exciting practice. So why is it you decided to leave private practice and seek a position as a magistrate judge?
It was an opportunity that came at just an interesting time in my life. Much like becoming a lawyer, I did not have some dream of becoming a judge. When I left law school, I didn't think about clerking. I just wanted to get out there and practice. And it was a ways into my career before I really even understood the role of the magistrate judge in federal courts, because they're used so differently. And it was an antitrust case we had in the district in front of Judge Ballot and Judge Bostwick. That was the first time I really saw what a critical role a magistrate can play in a big complex case. And Judge Bostwick did such a great job of pushing the parties in. We had, it was more than 15 parties on the defense side we had in that case. And he did such a great job of managing fairly efficiently that antitrust case. And it was the first time where I thought, what an interesting job that is. That's somebody who, when you're slogging through discovery and trying to get your case ready, to have somebody who is efficiently managing that can make all the difference in the world. And that was really the first time that I thought, that's the only job I've seen other than the job I have that would be interesting. And I had goals in my life of what I wanted to accomplish in my professional career. And when this opening came up, I had been practicing for 20 years and just felt like I was ready for a new challenge, and thought I would throw my hat in the ring and see what happens. And I'm just thrilled that it worked out. And 3 months in, I joke, it's hard to believe this is only that many months. It feels like I've been gone from my firm for a very long time. Because it's such a different life now. It's hard to remember, even though I was in that life for 20 years, it just feels like we've been here for a long time. And I'm just very excited to have this opportunity.
Well, so now that you've been a judge for a few months, can you tell us what is the most surprising thing about being a judge?
I am enormously impressed with the lawyers who do criminal work. And I had no experience on the criminal side before starting. So I imagine they have been very patient with the judge who does not have that background. But I am incredibly impressed with the work that they do, in the time constraints they have to work in, and the number of clients that they handle, both on the prosecution and on the defense side. So that I've just been enormously impressed with the work on that side. And I have found the criminal work to be fascinating, complicated, heartbreaking. You don't really realize what a fortunate, privileged bubble you grew up in until you start reading criminal histories for people. And you realize how many challenges there are that many of us have been so fortunate not to experience in our lives. And I think you're just very grateful for the childhood you had, the people you have in your life, in a way that I naively did not fully appreciate before taking this job. So I think that's been the biggest surprise. I came in thinking that I would love the civil side. And honestly, I just find the criminal side just fascinating.
Do you also kind of have a sense that, I don't know, after you've dealt with a few discovery disputes, that, well, how does that compare to a little scuffle on a discovery issue in a civil case with somebody who's charged with a serious crime on the criminal side of things?
My surprise on the civil side has been the nature of the disputes that come to me. And your point is very well taken. It is very hard when you are dealing with somebody's liberty, and whether you are going to detain somebody who is presumed innocent before trial and put them away until trial, and to compare that in any way, shape, or form with a fight over whether additional documents need to be produced, particularly when you know the parties haven't really met and conferred on that. And so I think the civil side is challenging. Not that it's not important. I was a civil lawyer. I know what an incredible difference civil cases can make for plaintiffs. It provides medical care, it provides money to ensure they have housing and food, and those are incredibly important things. But I didn't really have a full appreciation for both the scope on the criminal side, because it's not just the hearings. I mean, I spend 2 days out of my 5 days in criminal hearings, but it's the search warrants that come in, and there are a ton of those. And it's all of the motions related to the criminal world. So it puts things into rather sharp perspective when you're looking at both sides of these. And I now understand, when I was a civil lawyer, you think the world revolves around your cases. And I think this just gives you a slightly broader perspective.
And that answer is maybe a good segue to the next question we have for you, which is, what advice would you have for attorneys who appear before you?
So on the civil side, all of my hearings so far have been by phone. My single biggest surprise is people appearing late for hearings. And it just is shocking to me. Calling in at the time that the hearing is starting is late. Calling in 5-10 minutes late is really late. And calling in after we've had to email you to tell you that your hearing has already started is really a problem. So that has been shocking to me. Ethan knows, if I had any reputation in our firm, is that I got everywhere early, because it was inconceivable to me that you would be late for a hearing. And I have just been unpleasantly surprised as to how cavalier folks are about appearing on time. I am also surprised at the pretrial conference time, how little some lawyers know about their case. That is surprising to me, that you have finished discovery and you have this document, which I acknowledge to every party in front of me is very challenging to put together. I think the pretrial order, if you're going to do it right, takes an enormous amount of time. But it's also your chance to be an advocate. And I'm surprised as to how many people don't take advantage of that, or haven't thought through what claims they even have at that time, much less the elements of those claims and what facts to support it. It's always surprising to me in the pretrial conferences where I say, I received your pretrial order. Your original complaint had 5 causes of action. You only list 2 in there. Are you getting rid of the other 3? Oh, I had 5 causes of action. Yes, yes, you did. Yes, you did. So that has been a surprise. I think the other surprise is the firm I was at before handled a disproportionate number of complex cases. And my practice in particular was really focused on those cases. So that is not reflective of the types of cases that are generally in federal court. And so that's been a surprise. I do think it's bold when lawyers try to argue to me that their cases are complex and that I might not understand complex cases. That's a less successful path for them than they may imagine.
So the advice might be better prepared, be on time, and maybe know your audience, know the judge's background, right?
Those are 3 excellent bullet points to take away.
Yes. Okay, good.
Yeah, good advice. And let me ask you a question, drilling down on the civil litigation piece. So when litigators come to you with, they hit a snag in civil discovery, for example, they want more documents, or maybe they're in the middle of a deposition and they have a disagreement and they want to call up the court. What is your view in those sorts of how to handle those sorts of disputes?
One of the surprises in this job from just the first couple of months is how quickly apparent it is that the parties have or have not met and conferred to exhaust that process. I think when you were practicing, you would often have the frustration of you were trying and the other side wasn't. And I think you would worry that the judge wouldn't be able to figure that out. It's very obvious, I think, at least on the disputes I've had so far, when they have truly hit a bump in the road that they can't get past versus they're just reaching out to get in front of the court, or they've hit the 30-day deadline in the district and they panic and they ask for a discovery conference. So I think so much really can be worked out by the parties. And one of the things that I loved about this district when I was practicing, and I say this all the time, is in discovery, there's already a case in the district on whatever your discovery dispute is. And you just have to spend the time on Westlaw to find it, because the magistrate judges write all the time in this district. And that's one of the great things about practicing in this district is you have roadmaps from the magistrate judges about discovery disputes. And I've been surprised how many disputes have come to me where there is clear case law in the district that answers it. It's not something where you're fighting about privilege or something where there really is a true, honest fight between the parties. And so in a lot of times, I'm just sending parties back saying, perhaps both sides should go read case X and meet and confer one more time. And if you need to come back to me, that's fine. But I've been amazed at those gentle nudges of please look to see if this dispute has been persuasively decided already in the district. And then if not, come back to me. It's resolved in a number of those disputes. And to me, that's just additional evidence that you're not fully meeting and conferring.
What is your practice as far as, do you instruct lawyers, say in the initial scheduling conference, that you expect them to contact you before filing a motion to compel, or is that your practice?
It is. That's my requirement. I loved that practice as a lawyer. I think motions to compel are very expensive to put together and respond to. And with the time limits we have, it can disrupt the entire discovery process, because if you're waiting 14 days for a response and 14 days for a reply, you've lost a month of the discovery period. And what I'm telling lawyers on the front end in scheduling conferences is I'm not giving enormous amounts of time for discovery. And so my promise to them is, because I'm doing that, I need to be resolving discovery disputes quickly so that I am not an impediment to them completing discovery in the time period we talked about. So I put in all of my scheduling conferences that when the parties have exhausted their meet and confer obligations, they are to contact chambers with an email that is sent jointly with a non-argumentative short summary of the discovery dispute. And then I bring the parties on the call. And what I have seen on those calls is I'm often sending them back to meet and confer one last time, because again, it's clear that they haven't really talked about all of the issues. I'm giving them guidance as to what my reaction is to the discovery dispute so that they can go back and think about that again. And then if they don't resolve that on the next meet and confer, I am ordering expedited briefing. and sometimes it'll be simultaneous briefing. It's very short pages. It may be 3 to 5 pages on a discovery dispute. And then we're trying to rule on those as quickly as we can so that I can ensure that the parties are going and discovery is not disrupted by a dispute.
Very good. That sounds like a good process to keep things moving. That's good. Well, Judge Schwartz, this has been enlightening and it's been a real pleasure. Before we let you go, are there any tidbits of wisdom you'd like to convey to the practicing law members of the bar about the practice of law, just generally?
I would just say try to find the joy that you can in this practice. I think that being a lawyer is an enormously tough job. You're constantly dealing with, pressure from clients, from the court, from colleagues if you're in law firms. I think that it's an enormously stressful job. And I think everybody needs to find time within that, whether it's for your family, your extracurricular activities, whatever you can to find those outlets, to find the joy, to release stress. And I think too often it's hard to find and to build in that time in the practice of law. But I think as you look back on, for me, for a 20-year career, as proud as you are about your career and your accomplishments, it's the stuff outside of it that's the important. And I think we lose track of that when we're being lawyers. It's hard to build that in. So I would just encourage people to try to find the balance that they can. I've had multiple scheduling conferences where you can hear lawyers are hesitant to say things like, you've set the trial date for X date. That's the day that my child is graduating from college. I would like to be able to go to that. And absolutely, everyone should have a life outside of the practice of law. And I hope that people appearing before me know that those are things that I want to build into schedules to ensure that we get to be people outside of being lawyers. So I think that's one of the takeaways I would give to people, is just try to find that balance where you can. And if you're candid with your courts, hopefully they're willing to incorporate that into scheduling and everything else to make sure that we all get to be people outside of being lawyers.
Hear, hear. I second all of that. What do you think, Ethan?
I do
As a
too.
practicing lawyer.
I do too. I appreciate that. Thank you, Judge Schwartz. I really appreciate your time this morning and letting us interview you. And again, welcome to the bench.
Well, thank you both. Ethan, I miss working with you every day, but it's a pleasure to see this. And Judge James, thank you for everything as I've transitioned here to this job. Your assistants and the other magistrate judges, it is hard to put into words how appreciative I am of all of the guidance and the help and the answering the unexpected questions. So thank you. And it was my privilege to be here today. Thank you both.
You are more than welcome. And I know I speak on behalf of all of the District of Kansas judges that we're thrilled to have you here with us. So thank you for the work you're doing. And it sounds like you're off to a good start. And thank you, Ethan. It's always great working with you, Ethan, on our FBA matters. So.
Always my pleasure.
All right. Thank you all. Take
Thank
care.
you.